Maxi, should we begin? I see it's 12 o'clock. We've got all of our panelists. Welcome, everyone. My name is Jonathan Ripley Evans. I'm a member of AFSA International. Welcome to this rather exciting webinar. We believe it's very exciting, particularly from a South African perspective. Two main reasons why we think it's exciting. Number one, we're starting the public consultation process on a set of international arbitration rules which might be quite different to those that local practitioners in South Africa may have used before. It's the start of what we believe is a reform of arbitration in the country, and we have enlisted the services of some of the leading minds in the world to assist us with this process, some of which have joined us today for the call. Before I hand over to our first speaker, just a few matters of housekeeping. The first one, please note that this event is being recorded. AFSA is recording this for their purposes. The second thing is in the chat function on the right-hand side, you will see a link that I circulated for a copy of the rules. Do yourselves a favor, if you can, download a copy of those rules now so you can follow along with the conversations. Those rules are accessible on the AFSA website, and we'll also confirm the email address a little bit later, but after the webinar is complete, we're going to be asking for comments and input on those rules, and we ask that you please submit those comments via email to AFSA. Maxi will address that in a moment. If you do have questions as they arise throughout the webinar, please feel free to submit them. I think that the best way to deal with this is to do a Q&A session towards the end of the presentation. If you'll type in your questions into the Q&A text box, we will then try and address as many of those questions as we can from the panelists to get some clarity. The purpose of this webinar is not to go line by line through the rules. Maxi will talk you through all of this just now, but it is essentially the launching of these rules for public comment. So please bear that in mind, particularly if you have some rather detailed questions that need answering. We might need to respond to those questions in writing from AFSA's perspective, or take into consideration those comments when the revision is being done. Without further ado, I'd like to introduce you to our first speaker, Advocate Patrick Lane. Those of you who practice in South Africa will no doubt know Patrick. He's the current chairperson of AFSA International. He's also the vice chair of AFSA. And without saying too much, I'd like to call on Patrick to say a few words on the process.
Yes, many thanks, Jonathan. I trust everybody can hear me. I am unmuted, I believe. It is, in fact, just to echo what Jonathan has said, a much anticipated and exciting occasion now to see these rules eventually launched. The International Arbitration Act, which was published in 2017, marked a fundamental change in arbitration in Southern Africa. What it needed, though, was institutions to step up to the podium and meet that challenge. It presented its own challenges. AFSA had already received a number of referrals of international arbitrations, and in anticipation of the promulgation of the Act, formed its international committee. Obviously, its first task was precisely what we're about today, and that was to produce a set of rules that was suitable for international arbitrations. Just to give you an idea, at present, AFSA is already administering over 70 international arbitrations. Whilst being guided by Arbitral, one of the major challenges in drafting the rules was to take cognizance of particular local conditions in Africa, and in particular in Southern Africa. AFSA, who has recently been recognized as a leading institution in the survey of arbitrations in Africa, conducted by the School of African and Oriental Studies, was keen to publish a set of rules. We were incredibly lucky to have the volunteer of a team of highly respected draftspeople who prepared to offer their services and time under the leadership of Maxi Shearer to draft rules. All I have to do now is to thank them, and I'm sure you will see from what you read and what you are told, just how tremendous their effort has been in producing cutting-edge rules for international arbitration. Thank you.
Thanks, Patrick. I'd then like to hand over to the chairperson of the drafting committee, Professor Dr. Maxi Shearer. Those of you who are active in the international arbitration space will know Maxi, no doubt. Maxi is special counsel at Wilmer, Cutler, Pickering, Hale and Dorr in London. I now call on Maxi to lead us through the discussion as to what the drafting committee has actually done and where we're going from here. Over to you, Maxi.
Thanks, Jonathan, and thanks as well, Patrick, for the kind word of introduction. I'm very excited to be launching these new international arbitration rules of AFSA with you all today. It's been indeed a great pleasure and honor for me to chair this revision process. We started work about a year ago, and we had a very ambitious timetable leading up to producing these rules early 2020 for the then planned Johannesburg Arbitration Week in March this year. As you will know, or as you will have guessed by the date, that event unfortunately had to be postponed due to the COVID-19 pandemic. And therefore, we are even more excited today to be eventually be able to launch these new rules for public consultation in form of this webinar. As Patrick has said in the introduction, the aim of the drafting process was to produce modern rules that consolidate best practices from an international perspective. We took, of course, into account the specificities of Southern Africa, the South African Arbitration Act in particular, thanks to the input of many leading practitioners from South Africa, and the particular needs of the region as a whole, but the focus on international arbitration and international practices. And in light of that, we put together two working groups. First of all, an international advisory board with over 20 of the most renowned arbitration practitioners from around the globe, countries, of course, from South Africa and neighboring countries, but also from China, India, various European countries, and the Americas. Importantly, in that advisory board, we also had a broad spread of various professional backgrounds, practitioners from international law firms, academics, but also, and I think importantly, the users of international arbitration in form of in-house counsel of major international companies. The full list, of course, is on AFSA's website. And the advisory board has given us a very important and strategic feedback throughout the entire revision process of the rules. The second working group was the drafting committee. It's a smaller group of people with astonishing experience from international arbitration, in particular institutions around the world. I'll briefly introduce them. Some of them are here with us today. Others will be able to join for other webinars or podcasts that we are going to do over the next weeks. So in alphabetical order, Qian Bao, who is here with us today, is, among many other things, the former Secretary General of HKSC, the Hong Kong International Arbitration Center, and she is today one of the most sought after arbitrators from the region in Asia. Lise Bosnan, who is unfortunately not here with us today, is a senior legal counsel at the PCA, the Permanent Court of Arbitration in The Hague, and she's also the executive director of ICA, the International Council for Commercial Arbitration. She's, of course, South African, and she's an adjunct professor at the University of Cape Town. Rémi Gerbet, who's here with us today, a French national, is a partner at Momo Lacken, a law firm in New York, and indeed a colleague of mine at Queen Mary University of London. He too has many different hats, and he was the former deputy registrar of the LCAA, the London Court of International Arbitration, and during his years with the LCAA has gained very detailed knowledge of the working of those rules. We also have here with us today Ngdanka Kamau, who's again very many different hats. It's so difficult to choose amongst her incredible list of experiences. But among many other things, she's the vice president of the ICC International Court of Arbitration, which of course you know is one of the leading international arbitration institutions in the world. She's also the president of the ICC's Africa Commission and a former registrar at the LCAA MIAC, the Arbitration Center in Mauritius. So again, a very broad spectrum of experience from an institutional perspective. Jennifer Kirby, who is not here with us today, is based in New York and in Paris, and she was the former Deputy Secretary General at the ICC Court, and also very prominent, she is a very prominent arbitrator. Last but not least, of course, Jonathan Ripley Evans, who is here with us today, who does not need an introduction, whom I will not introduce. But what I would say is without Jonathan's energy and vision, this whole process would have not been able to succeed. So you see this as a drafting committee. We also had, importantly, the help of two excellent secretaries, Jonathan Lim from WilmerHale and Gregory Trayavani from Herbert Smith Freehills. And a big thanks also goes to both of them for their hard work. Without them, we wouldn't have been able to finish the rules in time. The reason I've gone through a bit of detail, the various drafting committee members, you will see the compact experience from institutional roles around the world, different arbitration institutions around the world. And as I said, the aim of the rules was to consolidate international best practices. But we also want to live up to the expectations of our users and cater for local as well as international audiences. And this is why we have decided to use this opportunity of a public consultation process to give everyone an opportunity to have a look at the rules and comment thereon to make sure that we have included everyone's, considered everyone's comments if they so wish. So as Jonathan said earlier on, the rules are on the website. There is also the link in the chat function where you can access the rules, the draft rules that is. And there is equally on the website a specific email according to which, using which you can send us your comments or queries about these new rules. And the email, you will find it on the website, is quite easy, comments@arbitration.co.za. So that is, we hope that you will be able to look at the rules and send us your comments and questions. Now, let's talk about the rules, the new rules. As I said, overall, they're consolidating best practices. They have certainly taken inspiration from the most successful arbitration rules around the world. If you look at them, you will find some of them mirroring other arbitration rules. For instance, we're going to talk about this a little bit later. If you look at the rules on party representatives and the ethical rules applying to them, you will see without much difficulty that we have taken inspiration here from the LCA rules. But in other aspects, the rules are innovative. For instance, they spell out clear provisions about transparency or about third-party funding, again, something that we will discuss a little bit later. There's also a specific provision for administrative secretaries to arbitral tribunals, something that is more and more widely used in international arbitration, and that we believed is important to regulate in the rules. The rules also foresee, particularly in light of the current pandemic of COVID-19, the possibility for conducting hearings remotely, using video conferencing as we do today. So there are a very modern set of rules. Now let's turn to our distinguished panelists, and we will spotlight which each of them particular issues on the rules. Of course, we cannot go in detail on every single one of the rules. So we have selected a couple of issues that we believe might be of interest to the attendees. So I'm going to first address my questions to Qian Bao. And we will start with the beginning. We'll start with the appointment process of the arbitral tribunal. Now, that in most cases goes smoothly and quickly, and the arbitration is up and running. But the question I would like to ask Qian Bao is, what if that process, for various reasons, takes time, and one of the parties requires urgent relief? What are the possibilities during that period of while the arbitral tribunal is being appointed for that party under the international AFSA rules?
Unmute. Thank you very much, Maxi, and may I congratulate you and the team for consolidating all of our respective submissions and contributions in analyzing these rules. Certainly, I appreciate it as a gargantuan effort to be able to streamline a set of contributions from the speakers as well as the others who were not able to attend today, to be able to put together such an excellent set of draft rules for the public to consider. So many congratulations for that. I have been tasked with speaking about the emergency arbitrator provisions, which I think are a fascinating set of provisions which allow for parties to engage in emergency arbitration and get injunctive relief prior to the appointment of the tribunal. Now, this is a fairly new feature in international arbitration rules. Until approximately 10 years ago, emergency arbitrator provisions did not exist. And then one institution by one institution began to see that there was indeed a need for temporary relief before the tribunal was constituted. Part of the reason for this is because the tribunal constitution process may sometimes take up to 90 days, depending on whether you have a sole arbitrator or a tribunal of 3. And so many parties saw that this period was difficult because they had chosen and agreed to the arbitral process, but there was no mechanism to get injunctive relief outside the courts. And so the establishment of the emergency arbitrator provision came to being about 10 years ago. Now, the features in Article 11 of the AFSA International Arbitration Rules are progressive and fairly similar to the ones that exist in other institutional rules. I want to mention a few key features. One feature is that this emergency arbitrator exists only during the period of before the constitution of the tribunal. And that person cannot also then be the emergency or the tribunal themselves. So they have a specific and concise function for the arbitration process. Now, to commence an emergency arbitration proceeding, you must make an application before, at the same time, or following a filing of request, but prior to the constitution of the tribunal. So what this means is really you have a window before the tribunal is constituted, whereby an event might happen where you require injunctive relief, and it is at this time then you can apply to an institution for the appointment of an emergency arbitrator. Now, the AFSA International Arbitration Rules also provide fairly similar timelines as other institutional rules in terms of the appointment of an emergency arbitrator and the timeline by which the emergency arbitrator must make a decision in relation to that relief application. Some rules will have a shorter period of time, but the AFSA international rules have chosen 48 hours from the receipt by which the Secretariat has received the application and paid the administration fees and deposits to make the appointment. Now, this is a very important process for the institution because the institution has a very small window by which to appoint an emergency arbitrator. And of course, as with all arbitrators, there must always be a conflicts check, and there must also be time for the emergency arbitrator to respond. And so you can imagine how urgent and tight this 48 hours might seem. In practice, what other institutions are often seeing is that emergent arbitrators, the institution will receive a phone call from the party seeking an emergency arbitrator prior to the filing of their application, to give the institution heads up as to the fact that they will be filing, and then the process will have to begin. So this is an important period for the parties to understand that this period of appointing an arbitrator within 48 hours is quite tight, and so institutions should be made aware of it prior to that appointment. The other period that I mentioned is 14 days, which is the life cycle of the emergency arbitration proceeding. The 14 days is about average for amongst institutional rules. I know that SCC has provided 7 days, which is much shorter. And you can imagine much tighter, whereby the emergency arbitrator has to issue a decision within those 7 days. But the average is 14 days, and in many circumstances you will see that this is approximately as well paced as you can get for this kind of injunctive relief. The other aspect that I want to highlight under the emergency arbitration provisions under the AFSA International Arbitration Rules is the paragraphs or section 17 in 17, which states that the emergency proceedings before the emergency arbitrator shall be terminated if the request has not been submitted to the Secretariat before or within 7 days of the receipt of the application. So this is another moment that the parties will have to consider that they are truly engaged and in good faith looking to commence the arbitration, and therefore have to issue their request for arbitration or submit their arbitration within 7 days of filing this emergency arbitrator application. And in relation to Article 18 or Section 18, this is also an important aspect because it reflects the fact that these provisions are effective after they have concluded their arbitration agreement before the effective date, and the parties have not agreed in writing to opt into this article, or the parties have agreed in writing at any time to opt out of this article. So this opt-in, opt-out is also important to consider when parties are negotiating their arbitration agreement under AFSA International Arbitration Rules.
Thanks a lot, Chanbao, for this overview of emergency arbitrators. And having set myself as an emergency arbitrator under various rules, it is indeed something that it's quite impressive what you can get done in such a short amount of time, and certainly has become an important feature for all international arbitrations. Now, let's consider another hypothesis, now not needing any urgent interim relief, but maybe just a normal case of arbitration. And a lot of those normal cases of arbitration have maybe a lower amount in dispute. They're not necessarily all the billion-dollar or round cases that we all consider. So what can be done for these lower or maybe simpler cases? Is it possible for the parties to say that they might want to get done with them in a shorter amount of time compared to what is typically done in average in international arbitration? Tian, if you could address that question, please.
Thank you, Maxi. Certainly the provisions of these expedited procedure, which defines itself in the name, is an exciting feature of virtually all institution rules now. And the expedited procedure really, I think, reckons with the time and cost issues that parties have long been complaining about in International Arbitration, and really addresses the fact that not all procedures are created equal and not all disputes require the fulsome approach that normal international arbitration rules provide. And so this tool that parties have at their disposal under the AFSA international arbitration rules are quite handy, and I think should be well exercised and well promoted, because fundamentally they apply to smaller value disputes or if the parties agree. And the beauty of the fact that parties can agree to expedited procedure is that the monetary threshold that applies, in this case, $500,000 US, is in fact not necessarily the only type of case that is not the only type of case that is available for these types of procedures. So parties can, with large disputes, can in fact engage in or agree to expedited procedures as well. And the features that are associated with the expedited procedures are unique and are very helpful in giving parties better parameters as to how extensive document production should be, whether the tribunal should be issuing a fully reasoned award or an award based in summary form. And also that time limits under the rules can be abbreviated, because fundamentally the expedited procedures must be done in 6 months. And so this is a fairly tight timeline, but for many cases, if parties are diligent and cooperative, and the tribunal is well paced and can manage the case, the proceedings well, you can get a lot done. As Maxie had alluded to, under the emergency arbitrator provisions, you can get a lot done within 6 months. And so this is a feature, I think, that parties should look at very carefully at when negotiating their arbitration agreement. The 2 points that I wanted to highlight under Article 10 of the AFSA International Arbitration Rules are the provisions 3B, which states that the court may, notwithstanding any contrary provision of the arbitration agreement, appoint a sole arbitrator. Now this is an important point to highlight, because what it means is that if the parties have agreed in their arbitration agreement to 3 arbitrators, the AFSA International Court, under the AFSA umbrella, may still appoint a sole arbitrator. And the point of that is really to enhance the speed and the process of the expedited nature of the proceedings. But this has caused certain issues in the courts, and so it is important for the parties to be aware of a provision like this, so that they are expressly agreeing to 1 or 3 arbitrators when making that decision in negotiating their arbitration agreement. The other related point is paragraph 4, that states that by agreeing to arbitration under the rules, the parties agree that this Article 11 shall take precedence over any contrary terms of the agreement. Now, this is more of an umbrella provision that speaks to the same principle that I've mentioned in relation to the 1 versus 3 arbitrator.
Thank you, Qian Bao. And I should remind everyone that, of course, if you do have questions, you can use the Q&A function. Jonathan will, at the end, we will have some time, and Jonathan will, at the end, put some questions to the panelists from the Q&A function. We might not be able to answer all of them, but we still hope to address the most important ones that you can send us through. I have one last question for you, though, Qian, and that is, other than the expedited proceeding, there are now, in many rules, other provisions that relate to early determination of provisions. In national courts, litigation, very often courts offer something like a summary judgment proceedings or preliminary determination of issues. Is there a similar mechanism under the AFSA rules, international rules, and if so, what do they say?
Thank you, Maxi. Yes, under the AFSA international rules, there is a provision that's very similar, and that is Article 12, the early dismissal rules provision. Now, the early dismissal or early determination provision is a fairly new creature of international arbitration rules, and we're now only probably in the last 2 years have we start to see the introduction of such provisions. And so I congratulate AFSA for taking the important move of being a front player in in setting out these rules, these provisions in the international rules, because they may be used, and I think that they can be very useful in arbitration. Again, there will be, this is applicable in cases where parties, when a claimant may issue or file a frivolous claim or a claim without, as the Article 12(1)(a) states, without legal merit, or is manifestly outside of the jurisdiction of the arbitral tribunal. In these instances, instead of carrying on to the entirety of the arbitral process, this provision gives the arbitrators or the parties an opportunity to cut short that and dismiss these claims early and within 20 days. And then these types of claims have to be made within, applications have to be made within 30 days of the constitution of the tribunal. I don't think there's too much more to say about this other than the fact that they are a very helpful feature in the rules. How successful they are, I think, has not necessarily been seen or tested tremendously in even other institutions, but I think it is a useful provision to have at the party's disposal.
Thank you, Jian, for all these important elements. I'm now going to turn to Ngdanka and ask her the important question in practice: what happens if one of the parties, the respondent typically, is absent? So, as we all know, arbitration is based on party consent, but what happens if one party, despite expressing its consent in the arbitration agreement, decides not to participate? How do the AFSA international rules deal with that situation?
Thank you very much, Maxi. And perhaps I should start by saying how delighted I am to be part of this process of not only contributing to the drafting of the rules, but also to sharing some highlights on the rules in today's webinar. And I just want to highlight a point that I think has already been said before, is to commend AFSA for this process. It's not only important to modernize rules, but to also put them out for public comment, because it's only in the review of these rules by potential users that sometimes we pick up some of the limitations in the draft. So it's a very important process. And of course, to thank Maxi for her exemplary leadership, without which I think we wouldn't be at this point. So thank you for that. So as to your question on absent parties, in the arbitral process, one is often surprised at the amount of times that parties seem to either never show up or to disappear midway between the process. And we can think of different scenarios. Sometimes you have a claimant that puts in an application and then doesn't pay a deposit or is unable to pay the deposit. And in that instance, the AFSA rules will provide for the arbitral tribunal to terminate the proceedings. And this you find in Article 17 on written statements. So if a claimant does not submit its statement of case, then the arbitral tribunal may decide to terminate those proceedings. But what we see more often is a case where the respondent doesn't show up. And in that instance, again, the discretion is with the arbitral tribunal to decide whether or not to proceed with the arbitration, and it may then proceed to issue an award or awards in the dispute. So really, this determination at the point when the arbitral process has started, so this is where the claimant has already paid its deposit and the arbitral tribunal has been appointed, then the decision rests with the arbitral tribunal as to whether to terminate the proceedings if the claimant stops the process, or to continue with the proceedings if the respondent is absent. And we may also think of a case which is not specifically dealt with in the AFSA rules, but we sometimes see in practice, is where a claimant files a claim, proceeds with all the requirements, and the respondent files a counterclaim, and then the claimant stops participating in the proceedings. And here, while it's not explicitly dealt with in the AFSA rules, I would expect that the Arbitral Tribunal would have the power to decide to continue with respect to the counterclaim. And I'll stop there and leave it for questions later on, perhaps, Maxi.
Thanks a lot. You unfortunately have picked some of the more technical questions. The next one is actually a quite complicated one about multiple parties and multiple contracts. The way modern businesses are structured, commercial transactions are structured, maybe sort of multiple supplier or supplier and a supplier contract is that we sometimes have multiple contracts that relate to the same dispute or multiple parties that are involved in the same disputes. Can you help us a little bit about how these are dealt with under the new international arbitration rules of AFSA?
I'll do my best, Maxine. And as you say, this really goes to the heart of modern business. And we see different arbitral institutions around the world grappling with drafting rules that are fit for purpose, so to speak, to accommodate the different permutations that you find with respect to multiple parties, multiple contracts. So I'll answer this in three parts. The first will be with respect to the provisions in the AFSA draft rules on joinder and intervention. The second part is on consolidation. And then the third part, I'll look at the question of multiple contracts. So starting with the question of joinder, what the AFSA rules foresee, and as with many other rules in other arbitral institutions, is that there may be a request from one of the parties, that's a respondent to the claimant, or indeed a non-party, to be joined to the arbitral proceedings. Now, this may be for several reasons, and the commercial realities of those reasons will vary. But the important point here is that the AFSA rules have made a distinction about the point at which this application for joinder is made. Now, the application for joinder will be made either at the point where the arbitral tribunal has been constituted or when it hasn't been constituted. So let's start with the first scenario, the second scenario perhaps, and then the first one. So if the arbitral tribunal has not been constituted, the decision on joinder will be made by the court. And here, the conditions that need to be satisfied are, in order for the court to take its decision, one, that all the parties agree to the joinder. That's straightforward enough. And then the court will then have the opportunity to take its decision. Or in the second scenario, where the additional party or parties are prima facie part of the arbitration agreement. So these are the two sort of prior conditions that need to be met, not cumulatively, before the court can take its decision on joinder. Now, if the arbitral tribunal has already been constituted, then the arbitral tribunal will take the decision on joinder after listening to all the parties, giving all the parties an opportunity to be heard, including the party that's to be joined. Now, these scenarios can get very complicated, where you have 2 or 3 parties to be joined, where you have a party that's not already a part of a non-party that's requesting joinder, and this joinder is being resisted by both the claimant and respondent, or being accepted by one. So this can be very complicated decisions to be made, but the important point here is that they are made either by the court or by the arbitral tribunal, depending on the timing of the application for joinder. Another critical point to make here is that the decision on joinder does not affect the arbitral tribunal's power or its decision on its own jurisdiction over the claims. So you can imagine a scenario where the court, for example, decides to join 3 parties. And when it comes to the question of jurisdiction, the tribunal decides that it does not have jurisdiction with respect to claims that relate to one of the parties that have been joined. So that's with respect to joinder. And the same will also apply where the arbitral tribunal itself accepts joinder and then has the opportunity later on to address the question of jurisdiction over the claims relating to the different additional parties. So that's on joinder. A second scenario is consolidation. Now here, this is an instance where you have more than one arbitral proceedings, and a party applies to consolidate them. Again, here the AFSA rules foresee that the application for consolidation can happen either prior to the constitution of the Arbitral Tribunal or after the constitution of the Arbitral Tribunal. Now, if the decision or the request for consolidation happens prior to the constitution of the Arbitral Tribunal, again, the decision here falls to the court. And here, the application for consolidation may be made, one, if the parties all agree. Again, you will see this is a common theme. If the parties all agree, then there's no problem. The question goes to the court. Or if all the claims in the arbitrations are made under the same arbitration agreement. Now, this is a key one. So, two conditions: one, the parties agree, or the claims are made under the same arbitration agreement. And again, here, as with the question for joinder, the decision by the court to go ahead with the consolidation does not affect the tribunal's decision with respect to jurisdiction. A second scenario that you might imagine is where the application for joinder is made to the Arbitral Tribunal after it's been constituted. Now, here things get a bit hairy. And the first criterion is straightforward enough. This is where the parties all agree to the consolidation. Therefore, the tribunal goes ahead and takes a decision as to whether to consolidate. The second scenario or criteria is where the claims are made under the same arbitration agreement, and the Arbitral Tribunal is the same in all the arbitrations that are to be consolidated, or has not been constituted in the other arbitrations. So you have the first arbitration, which is the one in which the other arbitrations are to be consolidated into. Either you have the tribunal in that arbitration the same as the other arbitrations, or you have a tribunal constituted in that arbitration, but not in the other ones. So that's the second criteria. And stay with me here because things are about to get really hairy. In the third criterion is where the arbitration agreements are compatible. Now here we move from the realm of same to the realm of compatible. And you'll see, if you look at other arbitration rules around the world, institutions trying to grapple with how to define this compatibility. So you see sometimes they set out criteria that really amount to compatibility. So here AFSA is really trying to clarify the conditions for consolidation. So what happens in a case of compatible arbitration agreements? Well, here, first you have the compatible arbitration agreement, and the same situation with the arbitration tribunal as with criteria 2 with the same arbitration agreement, where you either have the same arbitral tribunal in all the arbitrations to be consolidated, or one arbitral tribunal and the others have not yet been constituted. It doesn't stop there. It goes on to say, and then you have 3 options. 1, you have the disputes arise out of the same legal relationship, or you have compatibility, arbitral tribunal, and the disputes arise out of contracts, one of which is principal contract, and the other which is ancillary contracts, or you have compatibility, arbitral tribunal, and the disputes arise out of the same transactions or series of transactions. And if you feel confused, that's fine. These are complicated questions, and are even more complicated when you have the facts. So it's really important when reviewing these provisions in this process for comment, to really think about the different permutations and scenarios that you might have, and the reasons that you might want to consolidate a dispute, and see whether these provisions satisfy those options. Now, the final comment to make on the consolidation is that, again, as with joinder, the decision taken by the arbitral tribunal or the court does not extend to the question of jurisdiction. And finally, if you haven't switched off you're sound by this stage. Third point, I promised you 3 items. The first was joint and intervention. The second was consolidation. And finally, multiple contracts. Now here, this is fairly straightforward and is rewinding to the point at which the claimant makes the claim. And here, this provision, which is in Article 28 of the AFSA rules, gives the claimant an option of either making multiple requests and concurrently making a request for consolidation, or making a single request and having additional information such that that application is deemed as a request for consolidation under Article 31, which is the one which you recall is a decision on consolidation taken by the court before the arbitral tribunal is formed. And again, here the court will accept the request for consolidation either in whole or in part, or reject it. And in this instance, if the claimant has chosen to go the route of making a single request, it will have to make additional requests with respect to the other arbitrations. And Maxi, I will stop there and hope that there has at least been something retained as with respect to the opportunity for the AFSA rules to cater for the complex legal relationships and commercial relationships that users will have.
Thank you, Ndanga, and you've certainly done an amazing job in breaking these complicated rules down to a very pedagogic level. The reason we wanted to include this in the seminar is, despite being them quite technical and complicated, and it's an inherent complex nature, we haven't made this complicated, is that in practice, these are instances that do arise quite often. There are statistics from other institutional rules that in a significant portion of all cases, a question of multiple parties of multiple contracts will arise at some point. So having these provisions in the rules is important to us, and it was important to us to touch upon them today. I should say at this point that we are planning, as I briefly alluded to early on, a number of follow-up training programs, little podcasts throughout the public consultation process until the point when the rules will be officially enter into force. So this is maybe something that might be the subject of a further training course if you're interested. Ndanga, I'm gonna maybe come back to you later on with some questions, but I'm mindful of time, and I also wanted to give Remy Jabin an opportunity to address us on the question of confidentiality versus transparency. Of course, confidentiality has been always stated as one of the big advantages of commercial arbitration. At the same time, over the past years, transparency of the process, but also the award at the end, has become an important feature as part of the discussion on international arbitration. How do the international AFSA rules strike a balance between these two aspects or relating principles? Remy, I think I can't hear you. Maybe take out your headphones just to be.
Can you hear me now?
Yes, yes.
All right. Apologies. So I think it's fair to say, Maxi, that there has been a push for transparency in international arbitrations in recent years. And I think some argue that increased transparency in international arbitration, and in particular with respect to the decision-making process, goes to the legitimacy of international arbitration. Now, part of the thinking, I think, is that because of privacy and or confidentiality, arbitral decision-making is a bit of a black box, and this creates in turn an uneven playing field between frequent users of arbitration and the so-called outsiders or new entrants. And anecdotal evidence, as well as empirical surveys, particularly the empirical surveys conducted by Queen Mary University in London and the one in 2018 in particular, confirmed that many users want to have access, if possible, to arbitral awards in order to be able to glean insight about decision-making processes in international arbitration. And so in the past, there's been a push for transparency. And just to give a few examples, in 2011, the French decree on arbitration removed the principle of confidentiality for international arbitration proceedings, preserving it for domestic proceedings. On a different plane, the ICC, for example, published a note to parties in 2019, which explains that for arbitral awards that were published after the 1st of January 2019, the ICC will publish arbitral awards in an anonymized or pseudonymized format unless a party objects. So there's this push for transparency. But at the same time, we also know from numerous empirical surveys that confidentiality is one of the most attractive features of arbitration for the users, and that in fact, many users of arbitration expect their proceedings to be confidential, rightly or wrongly. And so what the draft international arbitration rules of AFSA do and do nicely is strike a balance between these two competing interests of transparency and confidentiality. And the relevant provision is found at Article 36 of the draft AFSA International Arbitration Rules. So what does that Article 36 say? Well, first of all, Article 36 starts with the principle that arbitration proceedings are in principle confidential, unless of course the parties agree otherwise. So in other words, the AFSA rules follow the LCIA approach rather than the ICC rules approach in this respect. And crucially, this works by placing on the parties a legal obligation to keep the proceedings confidential. That obligation does not apply just to the institution and the arbitrators, but also to the parties. Now, what is the scope of this obligation? Well, it extends to keeping confidential any awards made in the arbitration, but also any materials which were created for the purposes of the arbitration. Think, for example, parties' written submissions or witness statements, etc., but also all documents produced by one party to the other in the context of the proceedings, and that are not otherwise in the public domain. So that is documents, for example, that would be exchanged in the course of document production. Now, Article 36 also contains a certain number of exceptions for this obligation of confidentiality, and that's the traditional exceptions where a party may publish information that is otherwise confidential when it is required to do so by a legal duty, or when it is required to do so to protect or pursue a legal right, or when it is required to do so in order to enforce an arbitral award, or apply to vacate or set aside an arbitral award. So that's the basic principle of Article 36, which protects confidentiality. At the same time, Article 36 provides at Article 36.3 that as a general exception to this principle of confidentiality, AFSA may, in principle, publish all arbitral awards in an anonymized or pseudonymized form, unless a party to the arbitration proceedings objects in writing to the publication and does so within a period of 30 days from the issue of the arbitral award. So AFSA will be able to publish these arbitral awards, just like the ICC does, but this is subject to an opt-out by the parties, which has to be made within 30 days. That's a shorter time period than some of the institutions like the ICC, where a party can object at any time until the publication, and the publication is typically is expected to be made within 2 years. So much shorter period really for AFSA. And so I think, again, the AFSA rules are both embracing change and transparency, and the push for transparency, and trying to strike a nice balance with confidentiality.
Thank you, Remy. One question to you, last question maybe, because we also want to have some time for questions from the audience on third-party funding. Third-party funding has become a feature of many international arbitrations, maybe not all of them, but some of them. There is, however, a potential for conflict of interest. And so my question is, do the AFSA international rules regulate that topic, and if so, how?
Yes, they do, Maxi, and it's a very interesting topic. It's also a difficult one because not only the practice of third-party funding is constantly evolving, the types of products offered by third-party funders, the types of funders, etc., and the use made by the users of third-party funding is evolving, but also the regulation at the state level of third-party funding is constantly evolving and varies greatly from jurisdiction to jurisdiction. So it may well vary from South Africa to some other jurisdictions. So it's a difficult topic to deal with, but at the same time, there is, I think, growing consensus that some sort of disclosure is needed when it comes to third-party funding. And so certain arbitration rules are still silent on the topic. It's the case of the LCIA rules, at least the 2014 LCIA rules. Some other sets of arbitration rules are already dealing with third-party funding, and that's the case of the rules of the Hong Kong International Arbitration Center. So the draft international arbitration rules of AFSA are dealing expressly with this issue, and it does so at Article 27 of the rules. And in short, what the Article 27 does is that if there is a third-party funding agreement that is entered into by a party, claimant, typically the funded party has an obligation to notify all other parties, the arbitral tribunal, as well as the institution, of two things, which is the existence of the third-party funding agreement and the identity of the third-party funder. So in other words, the provision does not go as far as requiring a disclosure of the terms of the funding agreement, which I think it's fair to say many observers would feel would go too far, at least many of the users of third-party funding. And of course, this obligation to disclose the existence of the third-party agreement and the identity of the third-party funders is to deal with the issue of conflicts of interest, to ensure that we have transparency and that arbitral members of the arbitral tribunals sitting in an AFSA case are not faced with conflicts of interest arising out of the identity of the third-party funder and the relationship that there may be between the tribunal or a firm and the third-party funder. Now, what's important is the AFSA rules are cleverly excluding from the definition of third-party funders party representatives. So a law firm that enters into some sort of contingency agreement with a party would not be captured by the definition of third-party funder, such that there would be no obligation to disclose that contingency fee agreement. Again, it was one of the key criticisms that had been expressed by the users of third-party fundings in reaction to the proposed regulation of third-party funding in different jurisdictions. And my reading of the rules, but the draft rules as they currently exist, is also that before the event insurance is not captured by third-party funding, such that there would be no need to disclose that. And I think that's in line with the practice up until this date. So in short, the AFSA, the draft international arbitration rules of AFSA on third-party funding are both innovative in the sense that they're not shying away from regulation of this particular issue, but they're doing that in a way that is nuanced and pragmatic, acknowledging that third-party funding is here and is here to stay and is going to continue to evolve, but at the same time ensuring that issues of impartiality and independence of arbitrators are covered.
Thank you very much, Remy. I'm going to hand over back to Jonathan for some questions from the audience, but I should certainly not do so before thanking our three distinguished panelists for their expert answers on those questions, and also for dialing in very early for Remy and rather late for Tian Bao. This is the disadvantage of having such an international drafting committee. So with that, a big thank you to both, to all three of you, and handing back over to Jonathan for some questions if we still have time.
Thank you, Maxi. Thank you, panelists. That was an incredible insight or view into what we can expect from these rules. And just before we hit the Q&A session, just a reminder, the rules are available on the website. Please download a copy of them. Please submit your comments to comments@arbitration.co.za. We'd love to hear from you. We'd love to hear your feedback. We are not going to have enough time to go through all of the questions that have come through. We're going to fire off a few of them now and get some of the more direct answers. Some of the more complex questions that have been raised are very good questions, and they may require a slightly more detailed answer. And so we'll explore the opportunity of maybe putting answers to certain select questions on the website for AFSA, but because we feel that our answer to some of those questions is warranted. Maxi, a quick question to you, just regarding security for costs. The question was asked, is there an option to request for security for costs, and in what circumstances?
Short answer, yes, there is. The provision provides broad powers to the Arbitral Tribunal to order security for costs. It does list a number of considerations that the Tribunal may take into account. The emphasis is may here. It is not a mandatory provision at all. As I said, the broad powers are for the Arbitral Tribunal to consider in which circumstances it is appropriate to order security for costs, but it is definitely a possibility, and it is Article 25 of the rules, draft rules, if you want to have a look.
Thank you, Maxi. I see that we have run out of time, but there's one question that I think that is particularly important, and maybe I can just give a quick fire answer to it before we sign off. The question was asked whether there are any features of the rules which are designed to attract parties outside of South Africa to actually use the rules, particularly sub-Saharan countries, to try and bring those countries into the conversation about using these rules. And then followed on from that is, are there specific aspects of the rules which are designed to take into account South African specific provisions under the International Arbitration Act in the rules themselves? And I suggest we deal with those in one way, but answering both of those questions. The fundamental thrust of these rules is to create a set of rules that are universally accepted, that comply with international best practice, and that do not create too many unique features that are foreign to a number of people. So in doing so, we're creating a set of rules that will look familiar and attractive to non-South Africans. But having done that, we have also ensured compliance with local law. We've consulted with a number of local experts, in particular Professor David Butler, who's the special advisor to AFSA, to ensure that the local rules do comply with South African law, but in a way which doesn't make them look unique to South Africa, so we can still attract the wider audience. Maxi, I think we've run out of time, unfortunately, to deal with some additional questions. But on that note, I really would like to thank Maxi and the panelists for your time today. It's been an incredible session today, and we really look forward to the future engagements with you on these rules. We encourage all of you to please submit your comments and engage with us so that we can address these in our future publications or podcasts and whatever we decide to do. And on that note, I'd like to thank everyone, wish you well, and we'll be in touch soon.
Thank you, Jonathan. Thank you,
Thanks very
Patrick,
much.
and thanks everyone for participating and asking the questions.
Thanks, everyone.
Thank
Bye-bye.
you. Bye.